Ted Ruger. I'm the Dean of the Law School, and thrilled to welcome you to this year's Irving R. Segal Lecture. Each year, the Segal Lecture brings together renowned oral advocates to speak about their craft and share with us what makes them the world's best oral advocates. This is a fitting tribute to Irving Segal, who was a 1935 graduate of Penn and a 1938 graduate of Penn Law School, and a leading member of Schneider, Harrison, Segal, and Lewis here in Philadelphia. Tonight marks the 30th anniversary of the Segal Lecture, and in those years we've brought over the years the leading lights of advocacy, predominantly here in the United States. Today we bring a guest who is very much in the tradition of the world's greatest oral advocacy, but one who brings a new dimension to the Segal Lecture. Harish Salve, one of the world's top oral advocates, one of India's top private attorneys, the country's former Solicitor General, and we're especially grateful that Mr. Salve has flown with us specifically to engage with us here at Penn Law tonight. This group in the room represents people from the law school, the Wharton School, across campus, engineering school, medical school, and all of us gathered to hear the insights from this leading advocate from India. Harish Salve's talk comes at an important time here at the law school and in our engagement with the world and with India and other Asian countries. This year we launched a new center driven by shared faculty expertise in China, in Japan, and in India, called the Center for Asian Law. And this center brings together the study of these and other countries in Asia in both a comparative perspective and doctrinal and theoretical perspective. And this talk kind of fits with our increasing interest in learning about insights in the U.S. legal system by drawing on insights and comparative legal analysis from top legal systems around the world. Harish Salve practices primarily at the Supreme Court of India and is known as one of the country's leading lawyers in the area of constitutional, commercial, and tax law. He served as Solicitor General of India from 1999 to 2002 and is also part of the Blackstone Chambers in London, one of that city's and that country's leading barristers' chambers. Throughout his career, Mr. Salve has argued a vast range of high-profile and landmark cases. Just last month, he represented the government of India before the International Court of Justice in an application filed by the Republic of the Marshall Islands against non-nuclear weapon states. Last year, or recently, in one of the biggest and most contentious tax litigations in world history, not to mention Indian history, he appeared for Vodafone International Holdings and successfully contended that the Indian tax authorities did not have jurisdiction to tax aspects of Vodafone's offshore activities. He has appeared for the government of India, successfully defending the India-Mauritius double taxation treaty, and appeared before the International Chamber of Commerce, where he successfully defended Devas Multimedia against the Amtrak Corporation, the commercial arm of the Indian Space Research Organization. Since 1996, Mr. Salve has appeared as amicus curiae many times in the Indian Supreme Court, assisting in environmental cases in what is commonly known as the green bench, which has resulted in significantly improving laws protecting the forest cover of India. He's been described as one of the biggest wildlife. This litigation has been described as one of the biggest wildlife conservation victories around the world. Currently, Mr. Salve is representing the well-known industrialist Tata before the Supreme Court of India in a case that will have far-reaching consequences for the rights of privacy in India. Salve's father, N.K.P. Salve, was a veteran Indian politician from the Indian National Congress and a member of the upper house of the Indian Parliament for 4 consecutive terms from 1978 to 2002. N.K.P. Salve served in a range of important ministry functions in the Indian government, but there's a more personal connection to Penn Law. Harish Salve's father also was guardian of our own Associate Dean for Global Affairs, Rangita Silva de Alves, and we're kind of thrilled to have this one step removed familial return to Penn Law. So for all of those reasons and more, it's my great pleasure to welcome you tonight, Mr. Salve, as our Segal Lecturer, and we are very much looking forward to hearing from you. I also just want to introduce and thank my colleague, Professor Sean Balganesh, who will help moderate the discussion that follows. And thank you all for being here. We look forward to talking.
Dean Ted Rugen, Associate Dean Rangeeta Nisambadia, Professor Balganesh, ladies and gentlemen. It was not just jet lag, but I'm truly petrified being here. After Rangeeta revealed a secret which she kept back from me. She gave me a list of lawyers who have spoken here before me. And if I had seen that list, I would possibly have to seriously reconsider my invitation. Maybe I would prefer to be a guest a few times before I gather the courage to go and say something. She also didn't tell me that I'd be the first non-American who would have this honor of addressing this gathering under the series of lectures in the name of such a famous lawyer, Irving R. I had to reschedule. I was supposed to be there in March, and I had to reschedule for a very strange reason. The government of India asked me to defend them in the International Court of Justice in a very strange case brought by Republic of Marshall Islands, a country I was in the press I hadn't heard of. I took a case who had initiated litigation against 9 states, 6 of whom refused to show up because they were not subject to the jurisdiction of the International Court of Justice. The 3 which showed up were India, Pakistan, and the United Kingdom. And this was against nuclear proliferation. And I always thought that was something they discussed in the New York General Assemblies or in discrete groups. But Marshall Islands felt that the International Court of Justice should directly sit together and negotiate. And arrive at nuclear disarmament. I don't know how that would be achieved. What I didn't realize is the amount of time that case would take for a commercial lawyer to understand how the international law is issued. What I also underestimated was the challenges written advocacy presents over oral advocacy, in the sense in the videos you also see me get up and speak, except I was speaking to a written text. And therefore, the first challenge was writing a good text, which would convince the judges. But the second challenge was keeping 16 of them awake when I read it to them. And that's when Rangeeta told me, so I said, I'll come in April, and she invited me. And I was not surprised that she was surprised as to what I was doing in the International Court of Justice. I've known her from early 90s, when she was being hosted by my parents in Delhi. And we were very proud of a new American restaurant over there called McDonald's. We took her for dinner. That's India. And she was surprised what she knew me. I started off as a chartered accountant, became a lawyer, to commercial law. And I was myself surprised what I was doing in the International Court of Justice. But then that's what Indian advocacy is all about. And in India, an advocate is supposed to be an all-rounder. We have our specialists who practice the regulatory side, who practice commercial law and corporate side, once it gets to advocacy, especially at a particular level, you're supposed to be competent enough to take on any challenge. When I was reading the biography of Irving Segal, I realized he was also a very rounded lawyer. And his years of conquest were from the 40s to the 90s. The 40s of Roosevelt included the legislation, the exciting things which happened in the Supreme Court of the US. The 50s, which for us, students of constitutional or comparative constitutional law, the most exciting years of the Supreme Court, the early modern years. The turbulent 70s, Nixon, Vietnam Wars, Watergate, the birth of investigative journalism, and one of the most oft-cited judgments, surprisingly in India, US versus Nixon. The first time I think the Supreme Court of the US were taken executive effectively. It will return to the roots in America towards a more conservative system in the 80s. And it's interesting because India has also followed its own path of evolution. And when I share with you what it has been to be an advocate in India, in some important cases, I cannot give you a full perspective unless I first give you a little introduction as to what India is all about, what the Indian judicial system is all about, what the Indian Supreme Court is all about. The 1940s saw the creation of the ideal of India. India was never a country. It's the British rule which brought India together and created what you see as the map of India. And the idea of India was born in the late 30s, early 40s with the freedom struggle towards the end of the war. The 50s saw an infant republic learning to survive. India was an experiment like never before. 375 million people in 1950. Twice the US population, a minute fraction of its resources. Heterogeneity in every facet of life. Language. We speak so many different languages, forget dialects in India. I can't make myself understood in all but one language in India. And there are 18 major languages, forget some dialects. And they are so different from each other. The food, the cuisine, the ethnicity, we still have Indians who talk in terms of the people who are Dravidian descent, people of Aryan descent, within the Aryan descent, people who are more pure Aryan, less pure Aryan. Our habits differ. Religions differ. We have the single largest Muslim population outside of India, much bigger than the Europe. And the greatest heterogeneity in India is of its pernicious caste system. India is feudal. I now spent half my life, or almost half my life in the UK. It's supposed to be a monarchy. Believe me, it's not half as feudal as India is. We have feudalism in our systems, in our DNA. And unless you understand that, you will not understand what makes India tick. The Indian Supreme Court has evolved as Indian society. The 50s and the 60s, the Supreme Court was a dispute resolution tribunal, which courts are supposed to be. The judges who came to first man the Supreme Court of India were, after all, judges from the Federal Court of India, British appointees, appointed under the Government of India Act. Who thought that the work of judges is to decide tax cases, to decide cases under the Contract Act, other commercial statutes, sale of goods law, and criminal cases? Judges have nothing to do with them. Occasionally, when laws were challenged to 15, they were all upheld. When the judges were told you must bring in due process, they said, no, we don't have due process. We have liberty in accordance with law made by Parliament. It was suggesting that we bring in due process when the Constitution was being drafted. One of the geniuses who was working on it, Professor Rao, a very eminent lawyer, he visited America. And I think he meant us, the famous story, he meant us to do a black road. Don't bring due process. It's unruly laws. So he changed the draft of the article from due process of law to procedure established by law. That's what the Supreme Court said. Look at the language of the Constitution. It's so clear. It was a very docile, in the sense of a very conservative, strictly by the book court. Till the late 60s, where we had some judges who started taking the government on. The only thing is the cause on which they took on the government was not a very popular cause. They fought the government who was doing away with property rights. Doing away with property rights has a very important historical context in India. The British ruled India through creation of a land system, what we call the zamindars. They recognized the locals as virtually ruling under the British patronage, and who would own villages and who would have all sorts of arbitrary rights to rule the country. And that's how the British ruled India, through these zamindars. And the first task of the first elected government which came into office in 1950 was therefore to dismantle this uneven system. But that's the only way we could have a republic in which there was some chance of equal rights, some chance of economic progress, some chance of social justice. But it didn't stop there. The dismantling of property rights in the late 60s started doing away with commercial rights. So we had a slew of nationalizations. The banks were nationalized. They are stuck now, they don't know how to re-nationalize. The railway was nationalized, the banks were nationalized, the airline was nationalized, Air India. It was a private airline, it got nationalized. Insurance corporations were nationalized. And it went on and on and on. And when it was nationalized, they would pay the face value of the share, which was a fraction of its real value. And that's where Supreme Court stood up and fought. And that's where Supreme Court was. The Constitution was changed. 73 was the highest moment of our Supreme Court, where it held Parliament can amend the Constitution. There is a power in the Constitution to amend it. But it said you cannot change the basic structure of the Constitution. At that time, the judgment raised a lot of eyebrows saying, what a basic structure. Basic structure. Today it is not only in India, but in some of the neighboring countries, very respected for them. Because certain basic values of a constitution, which we all understand, the right to life, the right to liberty, freedom of speech, freedom of conscience. This is what democracy is about. Those cannot be amended by law. Following this came the lowest moment of the Supreme Court in 1975, where they held that there was a phony emergency took place like India is in a grave internal crisis, because the then Prime Minister was a grave political crisis. The Supreme Court said, well, the emergency is in place. Even basic fundamental rights get suspended. So a person who's detained lacks the locus to challenge his detention. I don't think anybody superficially familiar with English or any law would understand why a person who is put in jail cannot challenge the decision to put him in jail. But that was the Supreme Court of 1975, after which it set about correcting course. The government changed, democracy was restored, the constitutional order was restored, and the Supreme Court realized it had to fix its image. And that is where the Supreme Court started changing. One of the young friends I met, they said, the topic of your speech evolved over a period of time. And the topic of the speech was Supreme Court of India to Supreme Court for all Indians. And that process started in 1978 onwards. The first thing we did is we read in due process. We read in a very wide right to life. Life means a decent existence, dignity, not animal existence. And you widen the access to justice. Anybody could move the court pro bono in public laws. So what was I doing at that time? We were young lawyers coming from the world of commercial law. I had the privilege of working with one of India's finest lawyers of his times, who was also at one time an ambassador to the US and Somalia, who belonged to the 60s and 70s, and who had some very strong words to use about the way the Supreme Court had suddenly changed face, allowing pro bono petitions, was taking on cases which involved dysfunctional jail, cases which took on dysfunctional old people's homes, cases which took on dysfunctional mental hospitals, entertaining petitions by pro bono petitioners saying bondage labor should be abolished, and stuff like that. People like him said, that's not what the Supreme Court for. Instead, we have tax cases, instead we have important cases of commercial law. What are they wasting their time doing all this stuff? But that's where the Supreme Court changed. And advocates in courts have a symbiotic relationship. If the court changes, if the perspective of the court changes, you have to change your advocacy. You have to change your notion of advocacy. You have to change your learning of advocacy. You have to change your style of advocacy. I remember sitting in court 2 years at the bar. There was an argument which I thought was very logical, connecting the Chief Justice, then Chief Justice General, who just looked at the law and laughed the argument away and said, no. And I thought, nobody is contradicted. I think it's a good point why is he contradicting me? And then the Chief Justice came to the retort and he said, what you're asking us to hold is not good for the country. So I said, yes, but that's not what the other side says. He says, no, we are not concerned about the truth you are saying. We have to look at this country. And we have to worry about the unseen faces and the unheard voices. I sort of scratched my head and I said, every time I present an argument, I wonder about what some lawyer was not appearing in the case would have argued against what he said. Now at this stage I realize what he was talking about, and he soon figured what he was talking about, the changed perspective of the court. The Supreme Court evolved from being a tribunal, which heard the two adversarial sides and decided a dispute. It had evolved from there into an institution of governance, which had to look at India with its teeming poverty. It had to look at India with its problems of caste discrimination. It had to look at India with the huge gender discrimination which was then present. It had to look at India where unemployment was the order of the day. It had to look at India where the average employment of a farm labor was a subhuman existence, level wage. And it had to look at all this before it accepted a proposition of law, which had any impact in public building. And that is what we have to learn. The impact of this mindset on taxation, the impact of this mindset on commercial laws, the impact of this mindset on affirmative action, the impact of this mindset on the evolution of environment, natural resources, public-private partnerships, securities control, commercial law, which are dealt with all over the world. Here, when they end up in the Supreme Court of India, this is what the judges are looking at. They are not looking at it purely as a court. They now regard themselves as a co-equal institution of governance, who has at times more responsibility than the executive government dealing with problems. So as a commercial lawyer, we had to change completely our style of thinking, our style of presentation. The first question now which we ask ourselves, and I learned this fortunately pretty early, is if I ask the court to accept a proposition of law, will they buy it? Will they look at it? Will they consider it reasonable? Where does this come from? The Supreme Court can overburden court, even another constitutional courts overburden. Huge docket here. Just to give you an example, I think the US Supreme Court receives about 3,000 to 4,000 petitions for cert, and they entertain, I think, less than 100. We receive about 50,000 each one is burdened over court, each one, like benches. And I think 1 out of 4 cases gets admitted, or 1 out of 5 cases gets admitted, out of which at least 700 to 800 appeals come up every year. And that's why this backlog of a decade. That's the kind of load the court is working under. And from the 70s, they are more concerned about service disputes between civil servants and seniority promotion, because those become very important. Criminal law, the last court of appeal in the Supreme Court, huge amount of criminal appeals, including by people languishing in jail coming through pro bono systems. So when you are presenting a case to a judge who's been hearing all this stuff, and suddenly you tell him, look at the Sale of Goods Act, he's not going to change his mindset. He's going to bring a public law approach into commercial. And I've seen that happen. I'll give you 2 or 3 examples. In 2005-2006, there was a huge dispute between the 2 promoters of a big company called Reliance, the gas case. Somebody has now written a book on it called Gas Wars. Most of these were fiction. And what came up in this broadly was that in a subdivision of the company between the 2 promoters, there was a term in which the company which held the gas asset, production sharing contract, the government, to supply gas at a particular price to the other promoter who was walking away with the power generation. And one of the defenses raised by the gas company for whom I was preparing was that there is a government approval required. And the price is too low, and therefore the approval is not forthcoming. Therefore, this contract cannot work. Now, this case ended up in the Supreme Court opinion. So, you are quite generally interpreting a corporate scheme of demerger and a commercial contract, a production sharing contract, which the government will be the party. If you read the Supreme Court judgment, it reads like a judgment on administrative. Natural resources, sovereign, constitutional right, the poor people of India, right to natural resources, contractors cannot walk away with these rights, etc., etc. Suited us, we won the case, they said we don't have to supply gas at this price. So where are we now? The next time he went, the gas company went and said, these wells are over 1,500 meters deep. Cost of these wells is very high. You're not going to be selling it at a higher price. And look at the contract. The contract says I can sell it at arm's length price. So you are getting imported gas, which comes in as liquid gas, regasified, supplied $14, $16, $17. I'm going to sell my gas at $8. Much less commercial price. The government said, no, you can't. You will decide. Say the contract says yes, but read the judgment. He said, this is a national resource. The people of India have a right to this. He gave a notice to arbitrate. We are still arguing 3 years down in court whether this dispute is at all arbitrable under the production sharing contract. Now this mindset, where does this come from? This is what the Supreme Court of India is all about. Now to deal with this mindset, you have to change your mindset as a commercial lawyer and try and find the middle path of sneaking through. The drug case, the Novartis patent case, I was preparing for the generic manufacturers. Very interesting story. When India signed TRIPS, they ran short of, the then government in office ran short of numbers in the upper house. And they realized it wouldn't be passed unless the left parties supported it. And for the left parties, TRIPS was an event. Somehow the government in office convinced them that if you didn't sign the TRIPS, it would be a huge negative for India, it would be out of global trade. So they agreed to signing the TRIPS with a rider. And we added a particular rider, the TRIPS got signed, we were allowed that. And that got enacted. And now we have the literature, they discussed with the left parties, who got some very young retired judge of the Supreme Court who wrote that and put it in about demonstrable efficacy of the new product. Telling in very simple language, but unfortunately the language of the previous customers. And this case reached the Supreme Court. And I was bearing, citing that provision and requesting the court to apply that provision. But I had to be careful because the judges would overreach and say yes, because ultimately drugs are for poor people. I said, no, that's not, yes. Drugs are for rich and poor people, that's not what this case is about. This case is about interpreting a provision of the patent act. The natural reach of the judges is so steeped in administrative law, so steeped in doing work on social justice. Imagine a judge who's been hearing a case about a drought in India and giving direction. But this is the kind of stuff our court does. Hearing a case about distributing food grain which is rotting. I mean, one would have thought the government would do it. There is food grain rotting in the Food Corporation of India's warehouse. There are people who are starving to death. We have starvation deaths in India. Unfortunately, that's the reality in the 21st century. And it means the Supreme Court to come and tell the government, why don't you distribute this grain? Somebody once asked me, is Supreme Court running the country? I said, well, as citizens now, the first thing I would say is thank God someone else. So, this is the real challenge. Judges who do this kind of work day in and day out, persuading them that what you're asking for commercially is not just a correct interpretation of the statute, it's in line with global thinking. That's what everybody says, and it is not going to damage you. And this becomes a huge challenge to commercial lawyers. The Vodafone case, when the case began, if you study the history of the case, it has a very interesting, if you study the case, you realize what's actually going on in it. Round one, when Vodafone purchased the share of Cayman Islands company, nowadays in the use of their own reasons. Cayman Island company, which share gave them control over a whole string of downstream companies, which at the end had companies in India which operated telecom systems. India had never heard figures like this. If in the US you tell somebody it's a $10 billion acquisition, well, it's big, but it's not huge. In India, billions of dollars were spoken, and it was a $10 billion acquisition. So it hit the headline news. Vodafone was the buyer, got a withholding tax on this. Why? Because the seller, Hutchison, is a Hong Kong-based company, and we have no tax treaty with Hong Kong. There's no way we can enforce anything against Hong Kong. So the tax department said, low-hanging fruit, let's go for Vodafone. Ultimately, they have to work in India, and we declare them a default company to Vodafone their license. So Vodafone started in order to purchase the share, you should have withheld tax. And they are wondering that they purchased a share of Cayman Island company in a transaction in UK, where money moved from a UK bank account to a Hong Kong bank account between two companies, a Dutch company and a Cayman Islands company. Where does the Indian tax withholding come from? So they went to a court of judicial review. And what happened? The tax department came up with so much dirt on the transaction, written about in social media, and bits and bobs of what's available on the net. First time Vodafone realized how Indian tax department had become net savvy. Downloaded stuff from the SEC, downloaded stuff from advertisements and said they're lying. They bought Indian businesses. If you buy an Indian business, you pay tax. You got thrown out of court around money. You have to go back to the tax department, file a request. Case finally came back to Supreme Court. That's when I got involved. Case finally came back to the High Court. We lost it. So Brown came back to Supreme Court. Simple, according to me, the simple question of law was, here is the share of a Cayman Island company, which is sold by a Hong Kong-based company to an English company. In a transaction in money which moves from a UK bank account to a Hong Kong account. I don't see how this is taxable in India. Share is not in India, property is not in India, the payment is not in India, the buyer is not in India, the seller is not in India. The argument should have taken a little longer than what it is taking me to say here. 1 hour max. So the classic case that they use Supreme Court, 30 minutes exactly. You'd be surprised after a 9-week argument, when I was in a hurry to close, I joined them. Then Chief Justice says, we know why you're hurrying up. You have an arbitration next week in London. And I told him, no, my lord, I'm fed up of my own voice. 9 weeks. Why? The question of law was very simple. What was difficult? I remember I met the UK finance minister at a dinner. And he asked me, he says, what do you think of the Vodafone case? I said, it has its pluses and minuses. So what are the pluses? I said, the facts are on our side, the law is on our side. So then what's the minus? I said, the number of zeros. That's true anywhere in the world. Look at what happened in the Vodafone transaction in Belgium. Look at how Starbucks has been beaten up in the UK. People said they will not drink coffee because they don't pay taxes. Google just settled the issue. Not just in India. There's a global mindset change. At one time, multinationals doing business in the what we call the most tax efficient way was passe. Today it is morally unacceptable. I had to explain to the Supreme Court that everything which Vodafone had done and its predecessor had done was morally explained. Nothing wrong. They had no bad intentions in mind. That took 8.5 weeks, the real argument took 2 days. That is the change which has come, and that is today practicing in Indian law is what advocacy is become about. The Indian Supreme Court has widened its powers hugely. And it deals with all kinds of stuff. Sports associations, private sports associations, we're discussing the deal. The BCCI, my pet peeve, I remember my father was very close associations. Chaired at one time it was broke, it was a small organization based on the most wealthy cricket associations. Cricket is not just a passion in India, it's almost a religion. And naturally, the amount of money now, they say when TV rights are auctioned, they are looking at 250 million eyeballs. That brings in some time. 80% of cricket finance, 80% of global cricket finance comes from India. So naturally, the BCCI becomes more powerful, the Board of Control of Cricket. I challenged their authority in the Supreme Court in 2005 and tried persuading the Supreme Court that the constitutional rights which protect citizens against arbitrary behavior of state agencies should be extended to the BCCI. That way, court said they are not a state and constitutional rights apply to the state. But they left a germ inside. They said, but following the English jurisprudence, they apply to football clubs. They said they have to act fair. That was good enough. That was the Supreme Court of 2005 moving ahead. Today we have an even more powerful Supreme Court. Because I have noticed one thing, and that's the only explanation I have. Nature of laws of vacuum. In physical life, as it doesn't tell us. When we had Mrs. Gandhi's government, she was a strong leader. I disagreed with a lot of what she did, but nobody could ever doubt. She led from the front. She was clear about her policies, right or wrong, and they would be implemented. The courts stayed in their place. Coalition governments shrank the governance space, with the government leading more and more contentious decisions to the Supreme Court. And the lowest moment of that was in 1992, when the mosque fell and there were riots in India. The Attorney General appearing in the Supreme Court tells the Supreme Court, the troops are waiting to safeguard the mosque, awaiting your lordship's orders. And the judges said they must await the orders of their generals, not Supreme Court judges. So next time you will say our troops are on the border of Pakistan awaiting your lordship's orders. Is that what governance is about? So it suited governments. We do not want to take controversial decisions saying get it sorted out in the court. I have been appearing for for companies which make genetically modified seeds, for example. Tests are ordered, they are challenged in court. The government civil servants call the manufacturer and say, please get a good lawyer to defend this, okay? He will be neutral. It's very politically explosive. You fight it and please win it in court. And then we are paying. Why? Because it's a controversial decision. It's taken onto the streets, there's a problem. 84 Bhopal legacy still goes on. When people who have not suffered an accident in 84 would have possibly died of old age, but cases go on, and the government goes along. Despite the settlement of 91, the government has now said to increase the amount, which Dow Chemicals, who didn't even know who Julian Carbide was in 1984, till it merged in 2000. So the government said, best of luck, please go in the case, otherwise we have a problem. So when governance shrinks, the court expands. And look at what the court is now doing to the Board of Cricket Control. I took the case back in 2015 to a much stronger Supreme Court. We got a very good excuse because the son-in-law of the president of the BCCI owned a team and he was caught betting on his team and gambling and letting secrets out and doing match fixing and stuff like that. Those were the allegations. So what the president of the Cricket Control Board did is picked up two persons whom he appointed as a committee saying they'll give a report. Within 24 hours they cleared him from the charges and he said everything's fine. We took this to court at a shot. What has ended up in 2015 is way beyond what we had to court. The court appointed a committee of 3 retired Supreme Court judges who have given a new architecture of how the BCCI should be. Who should be allowed, who should not be allowed, whether they should have single votes or multiple votes, whether politicians should be allowed to be office bearers. And now they are using their judicial powers to force the BCCI to incorporate all these conditions. Can they do it? Who knows? They say they can. Don't believe them. Go face their contempt power. It's simpler to say yes, my lord. So that's the Supreme Court of India. This is how the institution works. So when you are dealing with commercial law, when you're dealing with securities laws, I've argued cases involving security. They are always wondering, are you cheating some common man? He said, no, this has nothing to do with the common man. There are rich people who are shorting the share. And it's a small company, it's not, there are those many private. We hold this, what's going to happen tomorrow to the common man? That's the mindset of the judges. And that has been our real challenge. I've also been, for me, also it's changing hands. Appears in my case during the environment cases. One of the long-running case. It is a case which began in 1996 and into which I got drawn in by sheer accident. I was briefly in a commercial case, dispute between two contractors for felling of trees. And I was kind of nice fat fee on the first hearing. The second hearing, my client told me your service is not needed, you settled this. Very much I walked away from it. Till I got a message saying the judges have sent you. So I went back to this environment hearing. I've been asked, no longer required. They said, no. We are removing your client from this case. We are appointing you as the client security, and you widen the scope of this issue for enforcement of the Forest Protection Act 1980, Forest Conservation Act 1980, all over India. And that case has gone on, where I assume completely different. Now, the big challenge was, how do you bring in matters of sheer governance? Controlling forest is a matter of governance, it's not a matter of judicial adjudication. How do you bring this into judicially manageable standards, into stuff which can be done by court? One of the scholars from, I think from Stanford, Rosencrantz, has written a strong indictment of what the Supreme Court has been doing in forest cases. But she's seen the result, the kind of orders they have been making. Why did they have to do it? They had to do it because in 1950, 13 or 14% of India was forest cover. By 1980, it was 11%. The Forest Conservation Act was brought to say even the states at the federal level will not allow any diversion of forests without permission of the union government. By the time the Supreme Court took up the case, the forests were down to 8%, 9%. Somebody had to enforce the law. So, coming from commercial law, getting into this, I thought I had to give them a format. The format I gave them was appoint an expert committee. There is a statute in which you can read in a power coupled with environment protection, under which the government can appoint an expert committee. So first issue the classical recommendation, get a committee appointed. The committee gives reports which has statutory force. Then issue a second recommendation, compelling carrying out that report. Now that actually fits into the traditional mold. The constitutional court issued the recommendation to follow the law. That's what they are doing. Except when you see the result of what they are doing, it looks pretty much like it's not the Ministry of Environment, but the Supreme Court, which is managing India's forests. Like somebody else. Work in progress. I'm now, being a commercial lawyer, trying to go back to my roots, commercial law. I've done all this, and I found the best way to do it is through the international arbitration work, which is increasing in huge multiples coming from India. As India grows economically and has greater share of global trade, disputes arise, global disputes, resolved in commercial arbitrations. And that has been a great opportunity. Come back to commercial law to sit again with judges who see commercial law for what it is worth. I remember my first major experience in 2005. I was sitting as a co-arbitrator. There's a very eminent former judge in the English Court of Appeal, and Sir Christopher Stone. The first thing he told me is, after he welcomed me and offered me tea and told me he was in Calcutta, he says, Harish, you come from the common law tradition. Yes, sir. And he says, you know, the first rule of common law. The common law is read in tooth and claw. I said, yes, I remember it. And we heard to the case of Operation Vessel, which reached 3 hours later, after the Lake Anne, which is the maritime law, I realized it was flexible. And the Indian company which was to supply, or said 3 hours later, contract cancelled. They supplied on a pro tem basis, and the dispute arose on whether they had rightly treated the contract as cancelled. Half an hour before the arbitration began, Sir Stoughton said, the vessel came at 3 a.m. It was to be there before the the end of 5 days of submission by 2 eminent silks on either side, we walk into the room and he says, "So, my dear colleagues, is there anything which you heard which has changed the view we had at 9:45 on Monday?" I said, "Honestly, no, not at all." And we heard the case for another week because there were 7 witnesses we heard. And at the end of 10 working day hearing, he said, "We want to finish an hour early." So wound up. Before we went inside, Mr. Stoughton said, "As I told you on day one, the common laws went in 234. The rest of it came at 3 a.m. Breach of contract. Let's fix common damage." That was a refreshing change. I just thought, if it was in the Supreme Court of India, the judge would say, "So what? It was just 3 hours late. Did you really use anything? How can it matter?" I mean, your chairs must also have been celebrating New Year because this was 31st of December. Maybe the captain was partying with the vessels. He didn't realize that his cost of coming in late was $45 million to pay. So this is a completely new world or old world, depending on how you look at it for me. And I find it delightful to once again read a contract, read its English, and try and find out what it means, and not worry about some judge who says, "No, this is not fair." In fact, we were sitting in a moot court recently, and Christopher Lau, very eminent commercial lawyer out here in Singapore, and sitting judge of the Supreme Court for obvious reasons, and one name, sitting judge and myself. It was a moot court of a dispute on sale of goods. And both of us thought one of the participants, or the young lawyers, very well prepared, made the right point. Till our Supreme Court judge, who was on 1.5, completely unsettled in saying, "But what you're arguing is not fair." He said, "But what I'm arguing is the contract." He said, "Yes, but that's not fair." This is about Lau looked at me and blinked. That's an Indian Supreme Court judge. And that is really what challenges advocacy has all been. A new challenge is now dealing with another animal with which the Indian system is completely unfamiliar, with Indian courts are unfamiliar. And I don't know how they're going to look at it. And that's bilateral investment treaty disputes. The third chapter of Vodafone saga is now being played out before a bilateral investment treaty tribunal. Last 3 years, Vodafone has been trying to get a tribunal in place, which still hasn't happened. Hopefully it should happen in the next 6 weeks. And I would really like to see how the government of India reacts, considering after the law was made, every finance minister, including of the previous government, has said this was a huge mistake. We should never have done this. We have been horrible for the economy. This was wrong, and we promise you will never do it again. I'm waiting to see how they will defend it before a bilateral investment tribunal. But their first reaction has been worrisome. They have come out with a model bilateral investment treaty, which pretty much says, "You come to India, we promise you the moon, and we are so good, you don't need any dispute resolution." So let's not talk about arbitration here after the Indian model treaty. I believe nobody's going to sign it. So that's where we are. And those are the new challenges. Those cases have yet to hit the Supreme Court. And when they do, if they do, we will have to see. The lawyers of our generation, and the pressure under which we work, believe me, I'm not that old, but I'm seriously contemplating that, or at least scaling down substantially. But we work under tremendous pressure. You can imagine the cross pressures we work under. But I suppose we owe it to the generations to come to imbibe them with curiosity, knowing what the system is, knowing how it works, knowing what makes it, knowing what makes it tick, and of flexibility. Flexibility to be able to adapt and keep some semblance of order in a situation which is passing through such pressures. Recently, there was a case filed in the Bombay High Court, and this I give as a classic example. whether or not a cricket match should be allowed in Bombay, the first reaction would be, is that for a court person? But can a court be a mute spectator of the fact that people are committing suicide because they don't get water to drink in that state? Because the drought has been so bad this year. While water is being used by those who can afford to buy water, which is important. As a commercial lawyer, I was recently asked for advice. If the court rules out, will there be a claim in damages under the contract for breach, or is it force majeure? The answer is, I don't know. These are the kind of challenges we face. We have to keep this going. We have to get our court. One of the biggest challenges in this court is to explain to the judges that any short perspective based on their understanding of public good in India actually hurts India. The Vodafone bench realized that holding against Vodafone would damage it in the long-term perspective of investors. In every commercial case of any significance, that's the message which we have to give. The judgment of the production sharing contract, raising it to national resource and saying contracts notwithstanding, has resulted in 6 failed auctions. Nobody's buying into India energy. This will be balanced with how the court perceives its role in the system stabilizes. Till we come back into a system where the court becomes a judicial forum and no more, till government takes its due place. Keeping the fires of commercial order has been what I would consider one of the biggest challenges in my career. The only thing by which I have kept faith is by reminding myself of what the famous Arnold Carnegie once said. Civilization is a movement and not a condition. A voyage, not a path. Thank you.